Hey everybody, Todd Vandermyde back here for another edition of Freedom Steel. It's Monday morning, still a little dark out, the time change, so trying to get this one knocked out early. I'm going to go out to the club, jump in the seat of an excavator, and pull the motors out of a couple of TS14 scrapers so we can get one good motor running and get some of our equipment back up online. But anyways, thanks for coming back. Todd Vandermyde, former NRA contract lobbyist, Illinois gun law guru. And so we got an interesting piece today. So last week we had oral arguments in Maryland shall issue v. Frosh, which is a challenge to Maryland's pre-purchase pistol permitting regime, similar to Illinois' FOID card, although they require mandatory training and a fingerprint scan before you can even make your application for what would be considered a FOID card. Our FOID card covers everything. Theirs largely focuses around pistols. And so oral arguments were heard last week in front of the Fourth Circuit Court of Appeals, the same appellate court that heard the challenge to Maryland's semi-auto ban back in December. So let's give a listen to some of the things they had to say.
How we're asking you to look at it is that we want you to look at history and tradition. Bruin commands us to do so. And that history and tradition is talking about how it's furthered by the HQL license in respect to two historical traditions. One is restricting those who are dangerous or contrary to public safety from getting handguns. And two, a robust historical tradition of firearm competency and requiring responsible citizens to be trained in the use of firearms.
So what's that have to do with the analogs they talk about in Bruin? I'm still waiting for any remote founding era statute that had a restriction similar to what we have here.
And I understand your question.
Well, do you have one or not?
We do not have any. We were unable to find any that required advance permission.
What did he just say?
And I understand your question.
Well, do you have one or not?
We do not have any. We were unable to find any that required advance permission.
So here we have the government admitting up front they could not find a historical reference that this type of law existed in 1791. They could not find anything where the tradition, the history of our nation had laws that required you to go seek permission from the government before you were able to obtain a firearm, that you had to submit your fingerprints, that you had to go through all this training, and you had to do all this before you could exercise a right. So right there should be full stop. Game over, player one. That's what should be happening right here, right now, because based on New York, it is, does the text of the Second Amendment protect the conduct? The conduct is the acquisition of handguns. Yes, it clearly does. Now it is up to the state's burden to sit there and prove that there was some sort of regulation, law, something at the time the Founding Fathers ratified the Second Amendment, and that with that, they were okay with this type of regulation. They admitted they can't find it. They don't have anything. And that really should be the end of the case based upon the New York standard of review that was announced, that was elicited in the New York case. But let's listen to what else they have to say.
But when you look at what Bruin is saying, Bruin is giving us the roadmap in footnote 9 about what states are able to do vis-a-vis substantive
separate from history. So in other words, you have no history, but this footnote which says this other case exists out here that's not before us, that you want us to apply that standard instead of the 50 pages of analysis that the court actually engages. Like skip the history and just use this exception to the Bruin test.
So, footnote 9. What is this mysterious footnote 9 they speak of? Well, at the bottom of page 31 on the New York decision, the court entered a footnote. It's a rather lengthy footnote, but it says, to be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. So that's what it is. But what the state is attempting to do here, the state is attempting to say that because their permit to acquire a pistol is a shall issue permit, this is what they meant, that the shall issue permitting regimes, except this lawyer for the state makes one glaring mistake. It talks about 43 states shall issue. 43 states do not have FOID card-like pre-purchase permitting systems. Illinois has one. New Jersey has their FID. You've got something in Massachusetts. You've got Maryland that instituted theirs. Oregon passed their pre-purchase permitting by referendum in the last general election. But you generally don't have this. You have to go get a FOID card in order to be able to purchase, possess, acquire, have guns or ammunition. It's not around. We are the outlier. And so what they're trying to do is they're trying to morph this footnote 9 into referencing shall issue carry permits to any type of permitting system for the ownership or possession of firearms. They're trying to bootstrap that argument up because that's all they got. They don't have anything else. But let's read on a little farther into footnote 9. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. Notice they didn't talk about public carry in that reference with the state and how they said, oh, it's footnote 9, so let's continue. Rather, it appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearm safety course, are designed to ensure only that those bearing arms in jurisdiction are in fact law-abiding responsible citizens. And they likewise appeared to contain only narrow, objective, and definite standards guiding licensing officials, rather than requiring the appraisal of facts, the exercise of judgment, and the formation of an opinion, features that typify proper cost standards like New York. That said, because any permitting scheme can be put toward abusive ends, we do not rule out constitutional challenges to shall issue regimes where, for example, lengthy wait times in processing license applications or exorbitant fees deny ordinary citizens their right to public carry. Full stop. The entirety of footnote 9 talks about carry licenses. And this is where the state is trying to morph and twist the words of the court. But let's hear what else they've got to say.
We are not saying it's an exception to the Bruins.
I think you are. I mean, I know you don't want to use that word because it's pejorative, right? Like, I'm using it for that reason. But how is it not an exception if you're saying, yeah, we've got no history, but look at footnote 9, right? But look at footnote 9. It creates a different path, right? I think earlier it was referred to as a different analysis, right? Was the statement that was made. There's different analysis that's in footnote 9.
But the Bruin footnote 9 path requires history and tradition as a fundamental premise of the substantive limitations that are being addressed there. And I think that's the message that Justice Thomas, the majority in that case, and Justice Kavanaugh and the Chief Justice in the concurrence were saying that when you have substantive limitations, you can have procedural mechanisms to enforce them. That's what Judge Easterbrook said in the Seventh
Can
Circuit.
you turn to the severability and just help me understand? Do you make the argument that
Tell us succinctly, what is the
All right. This guy, he's, just what I said. He is arguing that if there is this shall issue, that there can be, in our procedural regulations, they're allowed to do some of that stuff. No. This is about carry permits, not pre-permission slips. But what did we just hear? That judge who queried them before is now back in the game. Let's see what this sounds like.
Tell us succinctly, what is the history and tradition you keep referring to?
Preventing dangerous individuals from obtaining deadly firearms.
That's a generic concept. I guess you've already admitted you have no founding era statute that's an analog to what Maryland does here.
We were unable to find any, but look at the Bruin footnote 9.
So, right there at the end, it about sounded like that representative from the AG's office was about to cry. This judge is having none of it. He wants to simply show me what historical analogs you have with founding era laws. We couldn't find any. And this judge is having none of it. These guys are trying to bring back this interest balancing. Well, we're trying to keep bad people from having guns. Irrelevant. Absolutely irrelevant to the conversation. Because it's about text, history, and tradition. And that's it. I think this is going to be very, very illuminating for us, because if the Court of Appeals in Maryland throws out and says, nope, Maryland's permit to purchase violates the Constitution as per the Supreme Court in New York State Rifle and Pistol Association case, it is a hallmark for us with the FOID card issue. And that's going to be, to have another state, we're going to have the benefit of a lot of litigation from a lot of other corners of the country on a lot of other issues, as we are involved in our big fight right now over the semi-auto ban, and that thing has more moving pieces and more twists and turns than a dragon's tail, but it is slowly working its way out. So, hey guys, as always, sounded like our side had a good day in court last week over the Maryland FOID card style law. So with that, please like, subscribe, copy and paste our link, pass it around on all your social media sites. We really appreciate all the support that we're getting out there. And as always, frag out.